Good afternoon. It is Thursday, September 18th, 2025, the third Thursday of this month, and it's 3 p.m. Eastern, which means it's time for Third Ear Thursday. Every month, or pretty much every month, I did skip last month if you didn't notice. I took a little break. I needed one. I think we all do. And we're going to talk a little bit about that today. But I do typically do this live Q&A webinar every third Thursday of the month at 3 p.m. Eastern. I invite you to come and talk to me about some of your questions. In particular, today we're going to talk about the Ames versus Ohio case. If you're not familiar with that and you're an employer or an employee, you definitely need to get up to speed because it has changed the way that we address discrimination cases in the workplace. So I'll give you a little background. The Supreme Court of the United States on June, I believe it was the 5th of this year, decided the Ames case. And the big things you need to know about that are, one, the new standard that I guess you could argue should have been the standard all along. However you feel about it, doesn't really matter. Here's what the law is. The law is that regardless of whether a plaintiff is perceived to be in a majority class, they are subject to the same standard. Their case is subject to the same standard of review. When we're talking about standard, that's what we're talking about, is the standard of review for, in the Ames case in particular, for a dismissal. So what happened in her case is she had filed a discrimination case based on sex discrimination. She said she did not get a promotion, and she also was demoted because she identifies as cisgender or heterosexual. So this is a white woman. So you can already hear she is probably perceived to be in a majority class two potential majority classes. And what ultimately happened, her case was dismissed because there used to be a standard of review for dismissal of certain lawsuits that said, if you are in these majority classes, you have to first show that your employer is one of those rare employers that discriminates against majority plaintiffs, against people that are white or heterosexual, for example, in her case. And so they said, you haven't proven that, so at the outset, we're dismissing your case. She then appealed, and it eventually made it to the Supreme Court. The Supreme Court said, hey, this is not a reverse discrimination case, although you'll see it referred to as that in a lot of the mainstream media. And the Supreme Court said what I've been saying for years. There's some reassurance, is that there is no such thing as reverse discrimination. That's something that we kind of made up to distinguish cases against majority plaintiffs, right? Or people perceived to be in those majority classes. And the Supreme Court said what I've been saying forever. And my law school professors have also said, it's not reverse discrimination. It's either discrimination or it's not. You know, if you really think about that, reverse discrimination does kind of exist, right? You maybe perceive people who are more like you as better, so you discriminate in their favor. And that's what really reverse discrimination arguably is, if it exists at all. So let's just get rid of that, is kind of what the Supreme Court says. Then there was a concurring opinion. So the Ames case was unanimously decided by the Supreme Court, which means all the justices agreed that we only have one standard for discrimination. And what we do is we look at all cases with that standard. So then in a concurring opinion, which means Clarence Thomas, right? Justice Thomas said, hey, I agree with this, but I want to be heard on a couple of other things. And in particular, what he said is effectively DEI programs will be scrutinized more heavily And that shouldn't surprise anyone. We have executive orders, we have DEI bans. So when we take these two things together, we take the same standard of review for all plaintiffs, and we look then at DEI programs that in an effort to create equity and address inequities from systems that have existed for a long time in this country. What happened in this is programs started to potentially like turn the tables, right? In an effort to lift people up who had been marginalized and give them opportunities, some people maybe were doing some hypercorrection is what we might call it, and that created some new inequities, right? Because we start then basing decisions on things that Title VII says are not supposed to be the basis of the decision. So in particular, and this is the AMES case, it could be that AMES alleges, and we'll see if she's able to prove that now that the case has been remanded back to the lower courts for a trial on the merits. We'll find out did her supervisor, who identified as LGBTQ, show preference to other LGBTQ employees, and did she make adverse employment decisions that affected AMES based on that? If so, then that would be illegal, and that's what's left to be considered still. This is what I want you listening for, is are you making decisions based on those Title VII characteristics, or also we have protections against age and disability discrimination as well. So even if you are intending to do something helpful by elevating people who haven't had the same opportunities, we get you, we appreciate you, but you have to do so in a way that does not create inequities for people who maybe also have had limited opportunities but happen to be, for example, white or heterosexual. That's really the discussion that is coming out of AMES. So if you're an employer, what you need to hear in this also is that cases will be easier to file for plaintiffs, and they will survive dismissal, right? They'll survive those early motions to dismiss potentially that we were used to seeing when the plaintiffs were members of majority classes or perceived to be. And that was something that Clarence Thomas stressed in his concurring opinion, is that it's the perception of it as well. And if you're familiar with the Americans with Disabilities Act, that probably is going to sound like something you've heard before, is that when we talk about disability, we talk about disability being a real disability, something that's been diagnosed, but it's also the perception of a disability. And that's why we're very careful about how we perceive someone who might be unstable or crazy, right? We want to be very careful with those kinds of characterizations, because it's not the thought necessarily, right? We all have these hidden biases that create thoughts, but it's what you do with those thoughts. Did you act on them in some way, including with your speech? In the AMES case, we're looking at what were the adverse employment decisions. And this is coming out of a couple of other decisions that you've probably heard about over the past couple of years. There was the Students for Fair Admissions, right? And that was the one that was a case against Harvard and some other schools that were using quotas for admitting people from marginalized communities. And some of the students said, hey, wait a minute, that means I'm not being considered based on my merits. So we said in higher education, no quotas. And what we're slowly seeing, as we expected, is that quotas in any kind of private employment may also be discrimination and will be scrutinized heavily. I think under AMES, it's pretty clear that you're going to need to justify those quotas, which is also what Clarence Thomas is saying. Even if they're well intended, you need to back them up with some sort of data that says, here's the justification for this particular quota and initiative. Can't imagine how that's going to play out and in a way that would be a lawful program, but you're welcome to try it. I would say don't do it without legal counsel. That's one of the reasons that I do these live Q&A. Then the other thing I want you to hear if you're an employee is if you do feel like you have been discriminated against and you maybe were hesitant because you thought, well, I'm white or I'm male, I'm heterosexual, I don't have a disability, whatever it might be. If you feel like you've been discriminated based on sex, race, color, national origin, religion, age, disability, any of those protected classes, it doesn't matter if the if you don't feel like you, quote, deserve to be considered in that, it's still worth talking to legal counsel about whether or not you have been discriminated against and if you have any action that you could take. Now, that always gets a little bit loaded for people too, because maybe you really like your job. I have clients all the time who really like their jobs. They like the work they do. They like most of the people that they work with, but they maybe had some sort of run-in with someone who identifies in a different protected class, and they're afraid of raising the issue because maybe the employer has a lot of people that also identify in those groups. And so maybe you haven't you haven't wanted to say anything because you don't want to rock the boat. You'd like to keep your job, so you just kind of suck it up and keep going. And one of the things that comes out of AMES is that you don't necessarily have to do that. I encourage you to still report anything that you deem in the range of potential discrimination. And so what that could be is somebody who uses a racial slur, and that could even be a racial slur against someone who is white. That's not something we're used to thinking about because it look, we do have a long history of using racial slurs against marginalized communities, which is even more harmful and more limiting. But AMES is saying one of the ways that we're going to eradicate any of this division is to come together and treat people the same. So that's what you need to be looking at. Is your employer treating you the same? And if not, speaking up can sometimes make a big shift. But again, going back to that concern of, well, I don't want to rock the boat and potentially lose my job. Well, first, right, remember that there are laws against retaliation, especially for people who are whistleblowers, who report potential unlawful conduct in a workplace. So you do have those protections. I know that would also mean you might have to file a lawsuit. But the big thing that I do is keep people out of court. And so one of the things, again, I can tell you is that when people come to me and they want to keep their jobs, I can work with them to try to navigate the internal processes to improve the relationships. And some of the ways that we do that is we learn to frame the complaint, not just as, hey, that person said something and here's what you should do about it, but always going in with a curiosity of what can we do about this? And I think when you engage your supervisors or human resources in the conversation that way that says, look, here's what happened. I really like my job here. I'm not looking to cause a lot of trouble, but I do feel like this falls into a category of misconduct, and I think it needs to be addressed in some way. What can we do to have this not happen again, to have people get along and understand what the boundaries are, where are the parameters around discrimination? If you open a conversation that way and you're focused on solutions, you often will get a different response. Now, I have also worked in settings where you take that approach and your employer is not receptive, and you do end up still having to file a lawsuit or a complaint with one of the government agencies to be heard. We deal with that step by step. So I'm always of the mindset is give people the opportunity to do the right thing, follow the internal processes. The Equal Employment Opportunity Commission tends to tell you to exhaust your administrative remedies, not because they don't want to deal with your case. Yes, there are backlogs, and there are huge backlogs, especially now that we don't have as many people in some of these agencies. However, it's more about two things in my mind is one, giving people again that opportunity to correct the behavior because usually your employer wants to know about these things before they become lawsuits, before they become very costly. The other thing that I find really helpful for people is that by working through that process, learning how to frame complaints so that you're heard, so that they're investigated, so they're taken seriously, it empowers you, right? And one of the things that happens, I'm a former litigant myself, and one of the things that has happened when I've worked with other people and what I wish had been done a little bit more for me was giving me the power back because I felt very powerless being in that discrimination, sexual harassment situation, and I didn't know where to turn. I was in a small employer, and the people that I talked to about things just kind of dismissed it. And that's something else that employers you should be listening for as well. And I was talking to some people yesterday who are leading their businesses, and they get all of this, right? They understand AMES, they understand the complexity, they understand the intersectionality of a lot of these cases. And I asked them afterwards because they were feeling rather confident, I suspect, that we're ready for AMES. We can handle all of this. And I asked them one question. How confident are you that the people that work for you also understand these complexities? Because that's where things go wrong. It's not necessarily at the CEO level, although I've seen it occur at the CEO level, but it's often at the first line manager level that we see some of these missteps occur. It's because an employee reports, the manager got some training, but maybe forgot what they're supposed to do, was very busy, didn't think it seemed like that big of a deal, and didn't take it through the appropriate processes. So no investigation was done, the behavior continued, it got bigger, it got worse, and then it ended up in a lawsuit. So that is one of the risks. Now, since I'm not seeing a lot of questions yet, I'm going to walk you through like just an example of cases that I'm seeing a little bit more of. And I'm fictionalizing some of the facts so that you don't know who they are. But when you think about this case, so we're going to call the plaintiff or the claimant Nancy, right, to just keep it simple. And let's just say I'm an executive, I've long worked in DEI. My work, most of my career has been to elevate marginal communities, right? To help workers from these communities find opportunities that are compatible, that they can grow in. I'm helping people find vendors who are also from marginalized and underrepresented communities. This has been my life. But then I have an employee, and we're going to call her Lisa, right? And Lisa has decided she wants my job. And so she files a discrimination complaint trying to get me canceled, saying, oh, Nancy said these terrible things. And so I think you should fire her, right? So did you hear that already? I mentioned that's not the first thing you want to go in and do. So Lisa probably should have been listened to with a little more scrutiny when she filed her complaint. However, on the other side, you still have to treat all of these complaints similarly. So in this situation, we now have a complaint against me, and you're looking at me thinking, well, okay, so it's two women filing against each other. They're on equal footing. Now, what if I throw in some additional facts? So let's say Lisa is she identifies as Hispanic. She speaks Spanish. Or maybe she identifies as Latin, right? There are some individual terms around that. But let's just say she identifies in a marginalized community. Now you look at me and you think, well, Nancy's not from a marginalized community. But what if I told you that I'm white, but I'm over 40, right? Protected class. Let's just say hypothetically I'm Jewish, both by ethnicity and religion. Maybe I even have some sort of disability. Now you're starting to go, well, wait, how do we look at this? We've got Lisa, who falls into two protected categories that we're aware of, right? So do we give her 2 points? And because I fall into 4 or 5 categories, do I get 4 or 5 points? And then we prioritize the claim accordingly. So what if Lisa had a few more things? And then are we going to just keep score? And is that how we decide who is more credible? Well, hopefully, you've been hearing enough to know the answer is we don't score. We don't score, and that is one of the things that got people into a lot of or problems, right? It's what lands cases like AMES in the courts because we're not scoring people based on which groups that they identify with. There is no hierarchy of protected classes. There's no calculation that should be done. If you get a complaint, regardless of who it's from, you need to investigate it. And you need to investigate it fairly and impartially. This is where people have been getting into trouble. So stop trying to keep score and then basically put everybody on the equal footing and investigate the claim impartially. And then if you get a counter complaint, right, that happens a lot of times that somebody files a complaint, then the other person says, well, wait a minute, right? So Lisa files against me. I said, well, wait a minute, Lisa's been doing a bunch of stuff too that I haven't said anything about. I was just tolerating it, but now I want her to be investigated also. You have to look at each one of those, right? Every single complaint. And that happens frequently as well, is these kinds of complaints come in and it's usually not one incident. This is the last straw and here are the things I haven't been telling you about. You need to investigate every single one. So hopefully this has been helpful. If you do have any questions, I invite you, I forgot to mention that earlier, that you can put them right in the chat. I'm happy to answer any of your questions. And obviously, if this is something you would prefer not to speak about publicly, you are welcome to reach out to me individually. This will be recorded. It is being recorded as well as live streamed. And I will put this on my YouTube channel and I'll have some other tools for you as well. One of them I'm going to drop into the chat right now, or I'm certainly going to try, as I do have a sheet that I've been using, a handout that I've been using for the webinar series that I've been doing with Spectra Diversity this year. We're calling it DEI for real, and the real stands for reassure, educate, activate, and help you lead, right? So that's why we're saying DEI for real. We know that things have been very confusing this year. And now with the AMES case changing the game a little bit on the standard of review, there's even more confusion. So happy to help you. Look forward to getting us through this so that we're really just looking at each other as people and assessing complaints individually, being fair, impartial, and doing the best we can to level those playing fields. Thanks so much and have a great day.